As always, I want to thank everybody for coming out this evening. This is I guess I'll wish everybody a happy anniversary, seeing as we've been together for a year now. And luckily, I'm going to assume the applause are there haven't been any cuts in a year. So, which I'm happy about. I know you are as well. Before I get into the evening, I do want to introduce a new team member that we have that if you haven't spoken to her or dealt with her, you will. We have Kelly Lydon, who has joined us recently. Kelly's been with us for about a month and a half now. Kelly worked with Julie and I at a prior law firm, so we have a very high level of familiarity with her, she with us, which despite that, she still joined us. But we are happy to have Kelly on board, and she, along with Julie and myself, are working on this case, and you may be hearing from Kelly, same way as some of you have heard from Julie in the past. So I just wanted to introduce her. You can now put a face with the name, and she's another individual who's helping us out on this case. Where we stand today, there's a good amount of news, but nothing earth-shattering at this point. The next report that we're going to have is the end of September, so we're about a month and a half away from the next report to the court. The litigation, as I think I've told you at the last meeting, the litigation in state court has been put on hold purposefully, and the litigation in federal court is proceeding. Just to give you a little bit of flavor as to how quickly the wheels of justice spin, and I'm being facetious in that, is we did have a conference with Judge Smith, who's the judge assigned to the case in federal court, and in order to schedule the various motions to dismiss that are going to be filed by, I believe, all but one of the defendants. So they're all going to seek to have the case dismissed against them, which was not unexpected. It's typical. And because of the volume of defendants and the fact that each one of the defendants will be filing their own motion to dismiss, which will require us, special counsel, to respond to each one of those motions, raising different issues and things like that. The time frame that the court has set for that process to be completed in terms of the briefing, the writing, is we get the last shot to respond, and we have for our last response until December 15th of this year to respond. Once that response has been filed, then the court will set it down for hearing, and depending on the court's schedule, it's likely hearings on those motions to dismiss will be heard sometime January, February. Could be as late as March. It all depends on the judge's schedule at the time. But that just gives you an idea. You know, the cases were filed in June. The very first step in the process is this challenge on a motion to dismiss, and it'll be 6 months before the briefing on all of that is completed. So that just kind of puts it in perspective for everybody as to how litigation is going to proceed. Now, while I told you that piece of news, which is not that encouraging, and it takes time, I can also tell you that we have been approached and are engaged in discussions with the defendants, and some of those discussions are in the line of settlement. So I can't reveal who, I can't even tell you at what stage we're at, but I can tell you that there have been discussions that have begun and we have proceeded with in terms of settlement, which may resolve some issues, at least for some of the defendants. In addition to the state and the federal litigation, we have sought to intervene in it's the Cypre matter. You've probably heard about it, seen about it. That is the portion of the litigation that dealt with the charitable assets of St. Joe's being ultimately transferred over to the Rhode Island Foundation. And we have asked We have asked to intervene in that case. That case is still open and pending. And we've asked to intervene in that case because we have made the argument to the judge that either he was not provided with the entire story of those charitable assets, or possibly was even misled. And so we're asking the court to allow us to enter into the case on your behalf to try to recoup some of those monies, if not all of them, into the plan, which the total value as of right now is approximately $8.2 million. It'll probably be less by the time all of that gets done because 4.5% of that has to be paid each year, so on and so forth. But that's what that piece is about. So if you hear about the Cypre matter, that is yet a third piece of litigation, I guess I'll call it, that's going on, and that involves exclusively the funds that are being held by the Rhode Island Foundation. As you know, Rhode Island Foundation was named as a defendant in the litigation. The reason for that is not because the Rhode Island Foundation did anything necessarily wrong. They were the recipient of these funds, which were the function of the court's order saying to hand them over, but they are the custodian of those funds right now, and so they're the party that would be the one to give it back to us. So with regard to the litigation, that kind of gives you a good snapshot to the extent that I can tell you what's going on, about what's going on with the litigation. Excuse me, and give you a little time frame in terms of how that's going to progress. Beyond that, with regard to the administration of the estate and the management of the pension fund's assets, many of you may have already interacted with them. I have moved away from Angel Pension Group over to a new group, GRS, Gabriel, Roeder, and Smith, who is serving in the same capacity that Angel served, in that they are the actuary for the plan as well as the benefits administrator. So if you have submitted an application for benefits or a change of address form, or if you've received an election and you want to submit that election so you can start your payments, GRS is the group that you'd be communicating with from this point going forward. They came on board sometime in the mid part of July. We had hoped that we would have everything in place with them by August 1st. We ran into what I will politely determine or call hiccups with Angel Pension Group. I'm happy to say that we are now at a point where the information is moving smoothly over to GRS. GRS, to their credit, has made it a priority, and it was the first pieces of information that we asked for, is that any information regarding any pending applications be transmitted over to GRS first. I wanted GRS to confirm the math to make sure that what Angel was representing as a completed application with calculations, that GRS agreed that it was in fact complete and the calculations were correct. And I believe, Julie, correct me if I'm wrong, that September 1st, any application that they had received that Angel had been holding?
I don't know that's all of them, but it's a substantial amount.
A substantial amount. Mm-hmm. So GRS has been working hard. Obviously, they're getting information, identifying what they're getting, and making it part of their system. While they're doing that, they've been processing these applications. And to the extent that Angel was behind, and they were behind to a certain extent, even more so than what had been represented to me, GRS has worked hard to get the majority of those, if not all of them, online so that anybody who had an election pending or an application pending would be in a position to receiving benefits on September 1. The latest will be October 1. So they're moving very, very quickly, and they will move to continue to process applications and elections as they get them. The feedback I've gotten from you is that GRS has been very responsive, very helpful. I know many of you had contacted Angel at certain times and were told by Angel, well, you got to contact the receiver on this. They just didn't answer the question. GRS is taking a much more active and proactive approach, and they are in fact either answering the questions or they are saying, we don't have the answer, but give us your number and we'll get back to you with the answer shortly. So I'm already more than pleased with the responsiveness and the diligence that GRS has shown in this case. In addition, I met with Mercer, which is the investment manager for the funds. They came up to the office about 2 weeks ago, and we went over the investment portfolio, performance, predictions, things of that nature, just to make sure that the current investment portfolio is appropriate for this plan based on the circumstances surrounding the plan. As you know, the market is not as strong today as it had been in prior years. We haven't had any major shakeups, but it certainly isn't growing the way that it was in prior years. That said, we have made some adjustments. While it doesn't sound altogether significant when you're balancing it against $83 million that are being held by the plan, some of the adjustments we've made have saved approximately $190,000 in fees. Do you remember the number? I believe, I'll confirm this, but I believe it was about $190,000 a year in fees that the plan was spending, but has now changed as a result of us changing the investment allocation. So that's positive in terms of the plan is spending $200,000 less. Again, when you compare it to the $82 million that we have, it's not a huge amount of money, but $200,000, I think everybody sitting here can agree is not an insignificant dollar amount. Beyond that, unless I hear from you to the contrary, I do not have, as I've said in prior meetings, any intention at the next report to ask the judge to modify benefits in any way. I've basically put the reports and a recommendation on benefits on the same time schedule. So I keep asking the judge to schedule a report 60 days later and then kick out that recommendation or that time for me to make a recommendation 60 days. And I will tell you that as I stand here right now, there is absolutely no intention to make a request of the judge that the benefits be adjusted in any way at that September hearing. Again, it's just for the September hearing, but you will know if something's going to happen before it happens. It will not be the court hearing, it will not be the first date that you hear anything if it's going to happen. Beyond that, I'm happy to answer any questions. I don't think that I forgot anything.
90,000 per year. Yes.
Oh, I apologize. 90,000 per year, not 190,000 per year. I guess that was wishful thinking on my part to add a 1 in front of it.
90's still good.
90's still good. 90's still good. But so $90,000 a year in savings in fees. And I have, in our meeting, I did go back to Mercer and I asked them to further look into the potential of reducing fees. I will say that number of 90,000, I have reduced the amount of assets that are invested in hedge funds. And the hedge fund piece is a fee-heavy investment. It takes until, I believe, it's the end of September, beginning of October, for all of the change that I've asked for to take place. It takes about 4 to 6 months for that money to move from where it is now into another investment if it's coming out of a hedge fund. So we'll see a further increase or reduction in fees as a result of that. So that's not included, and that may be where I'm getting the 190 from.
That's going to go from roughly 260 to 194, roughly.
So another 70,000.
Mm-hmm.
So that'll be a reduction of another 70,000. Julie's got the emails. I'm going by memory. So based on that, that's about as up to date as I can get you. Without getting into detail on the litigation piece and the specifics of what we've been doing. And I'm happy to answer any questions.
Any update on the public guarantee pension benefit? process with that?
Now, as of right now, same as I think I said at the last meeting and maybe even the meeting before that, the PBGC, the Pension Benefit Guaranty Corporation, has taken the position that they're quite frankly not taking a position. They're saying that we've reviewed the documents and the documents say it's a church plan, and so as far as we're concerned, it's a church plan. Well, I could have told them that because that's the whole problem. That's what we've been talking about here for a year now. And then they further went forward to say that to the extent that our opinion changes, it's going to be based on a determination either by the IRS and or the Department of Labor. I did receive a call from the Department of Labor maybe 2 months ago, might even be 3 now, where they said they were contemplating opening an investigation of the plan. I haven't heard anything since. That doesn't mean that they haven't opened an investigation. It just means that they haven't told me that they've opened an investigation, although I think I'd be one of the first to know. But so the long answer to your shorter question is PBGC has taken no position, and we are, I will tell you, although I can't get into details, that I'm very aware of that position. And myself, special counsel, and I've retained an expert who is the former, I think I told you, is the former general counsel of the PBGC, are actively talking on a regular basis to discuss different ways to deal with that and to maybe address PBGC, that type of coverage, HRSA, things of that nature. Any other questions?
I lived in Florida most of the year, so I don't know about the last meeting when you said Mr. Kilmartin was the one who was here as part of it. Can you please tell me, because I think it should be, I don't care about the money part, but I'd like to see guilty or something. So what did or didn't do what did he cause?
I didn't hear that last part.
What did he cause? What does Mr. Kilmartin do and not do that he should have?
That's a difficult question to answer, especially seeing as I have not included him in the complaints that we filed for the reasons I stated at the last meeting. The question was with regard to the Attorney General, we're aware that the Attorney General and his office was not sued as part of the litigation, but what exactly did he or did he not do? At this point, the best way that I can answer that question, because keep in mind, litigation, things change in litigation, so I don't want to take any hard line position on anything. But in general terms, the Attorney General, along with the Department of Health, are charged with reviewing the transaction where St. Joe's and Roger Williams were transitioned into Prospect Health Partners or the medical holdings. The Department of Health obviously reviews that transaction for patient care needs, making sure that there's continuity of care, that the care that those hospitals give today or gave at that time as a not-for-profit would continue to be given as a for-profit hospital when it changed over to Prospect and things of that nature. The Attorney General's office oversees the aspects of the transaction generally, not the patient care part, but they do have that kind of umbrella review of public good, public welfare, public trust. So they oversee the charitable assets and what charitable assets end up going to places like the Rhode Island Foundation. And they review the transaction generally to make sure that the transaction will not result in any either reduced care or harm to the citizens of the state of Rhode Island, which include you. The problem with the transaction process, and I've been involved in 2 of them, so I can speak to this somewhat from personal experience, is the Attorney General's office has a number of boxes it needs to check when it is looking at these transactions. And it has its staff, and it hires experts to look at these things. In my opinion, and this is just my opinion, as Stephen, not as the receiver, is the Attorney General's office is ill-equipped to deal with financial issues. And I don't really truly believe that they understood the impact that this transaction would have on this plan. And if they did, they didn't really consider it as significant of a factor in the transaction that maybe we believe it should have been. The legislature this past session has seen fit to make a change on that. So, although I think I used the term, this is closing the barn gate after the horses have all run out, for the next transaction, the treasurer's office, if there is a pension or some type of retirement plan, multi-employer, single-employer retirement plan, the treasurer's office will be brought in to evaluate the impact of the transaction on that plan and whether or not that transaction actually protects the plan in the way that we think it should. I don't think that the Attorney General's office is equipped with the level of expertise in that area, and that's why the legislature, and I believe the legislature agrees with me on that, and that's why they changed the legislation. So it's difficult to say whether or not the impact of that transaction on this plan was clearly understood by that office, understood but ignored, understood but minimized. It's very difficult to say at this point, and I can't really speak to that because there is an opportunity to amend a complaint. And if we find other things, we're still going through the documents. We went through the majority of the documents in order to compile the complaints, but that doesn't mean that the work is over. So there is a potential where others could be named in the complaint, or that other parties will say, you need to name somebody. They're necessary for this lawsuit. And so you have to bring them in. You can't proceed without them. So until that process has taken its course, I don't want to get into too much more detail than just kind of a general overview of what possibly could have happened. Yes.
I have a question. It's kind of far out, but I like an answer.
Okay. I'll try.
All right. We got the nurses, got the church plan, and now we got the teachers having trouble with the church plan. Okay?
Can you go up to the mic, please? So we can hear you.
Well, I'll say what she said. We've got the nurses so far with the church plan with a problem, and we've got the teachers with a church plan with a problem. Can I interrupt for 1 second just so I can clarify? So the plan that you have is we have an argument as to whether or not it was a church plan. That's part of where we have the ability to go in and make some of the allegations that we've made in the complaint. The teacher's pension, and again, I'm familiar with it. I've had discussions on it, but I'm not fully familiar with anything that's happened. But I think that I can say with a good level of assurance or a good level of confidence that the teacher's retirement plan for the Catholic schools in the state of Rhode Island is clearly, without a question, a church plan. Whereas your plan, there's a question on that. I don't believe there's a question on it for the teachers.
All right, well, my question is, the church plans are protected because the Supreme Court made a ruling that church plans were separate from other institutes being insured. Okay? With so much trouble with church plans, shouldn't not Attorney General maybe file something in the Supreme Court to challenge church plans?
Well,
Is that far out?
let me just clarify a few points. The church plan status distinction is a carve-out, is an exception to the federal statute, which is ERISA. So the ability to identify yourself as a church plan, the criteria in which you have to meet to do so, and then not having to comply with ERISA is all federal law. There are two things that can be done to address that. One is our federal legislators, White House, oh my God, Cicilline, Reed, there we go. Yeah, I forget the most senior one, and Landrieu. They would be the ones who would have to submit something to the House of Representatives and the Senate on the federal side to change that exception. Keeping in mind that just because a plan is a church plan, and let's talk about the teachers one for a second, because I think that is clearly a church plan. Just because you're a church plan doesn't mean you don't have to comply with ERISA. You can actually elect to be a plan that is covered, even though we are, the Catholic schools can say, that pension plan could say, even though we're a church plan, we want to be covered by ERISA. There are different reasons why you would want to do that. There are several reasons why you wouldn't want to do that, but you could do that. The other thing, and I believe many of you were at Treasurer Magaziner's press conference, and I believe the gist of what he is proposing is to say that in the state of Rhode Island, the legislature can leave you exempt and say you don't have to comply with ERISA. But in the state of Rhode Island, I believe he wants to submit legislation that says plans operating within the borders of the state of Rhode Island that are affecting Rhode Islanders should be required by Rhode Island to provide at least the minimum reporting required under ERISA. And the state can do that. The state, that's not trampling on the federal law. That's just saying, you've got your federal standard. If you're in the state of Rhode Island, we've got a standard too. And we want to make sure you do it. That's not law yet. But from my discussions with the Treasurer's office, that's the gist of what I believe he was proposing at that press conference and what he's going to try to put together and get passed through our state legislature. So that would change the game slightly. Again, for this plan, it's kind of a closing the barn gate after the horses have run out, but it will prevent, it'll be one more step in preventing something like this happening ever again.